Before starting a lawsuit against a doctor or a careless hospital staff, you want to know what's the likelihood that your case would settle if you go ahead and start a lawsuit, since you have no intention and no desire to want to go all the way to trial 2 or 3 years down the road. Would you like to know the answer? Come join me for a walk on this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is, it is impossible to know whether or not your case will settle before ever getting to trial, at least at the very beginning of your case. Before we even start a lawsuit in your behalf, it is a physical impossibility to know with any degree of certainty whether your case, number one, has merit, number two, that if we did bring a lawsuit against your careless doctor or careless hospital staff, whether they would go ahead and want to settle before we ever get to trial. There are many, many different factors that go into whether or not your case would settle. And at the very beginning, before you have an attorney investigate to determine whether in fact you have a valid case, it is impossible to know with any degree of certainty whether, number one, you have a valid case, and number two, that if you did bring a lawsuit against your doctor or careless hospital staff, that your case would settle and there would be no need for you to ever go to trial. The reality is that the best lawyers in New York who take on a case, a valid case, a case that has been vetted, a case that has a medical expert who confirms that yes, you do have a valid case, that your doctor or hospital staff violated the basic standards of medical care, and that carelessness was a cause of your injury, and that your injuries are significant and permanent. Even if you have great experts who confirm that you have a great case, it doesn't mean that the defense is going to see things the same exact way. Oftentimes, in fact, in virtually every case, they don't. They will fight us tooth and nail on every aspect of your case. They will fight us and claim that they did nothing wrong. They will fight us and claim that whatever they did wrong did not cause you harm and injury. They will argue that even if the doctor did something wrong and caused you harm, your injuries really are not as bad as you claim them to be. So at the very beginning, we already know that they will fight us tooth and nail on every single aspect of your particular case. Legally, we say that they will fight us on liability, they will fight us on causation, that's the link, the connection between the doctor's wrongdoing and your injury, and they will fight us on the extent of your injury, the damages that you suffered. So we know that at the very beginning. Now, having said that, does that mean that there will be no interest at some point, that they might be interested in settling? No, that's not what it means. Oftentimes, after the defense has done a full and thorough investigation, and after all discovery has been concluded, meaning that all depositions, pretrial question and answer sessions have taken place, and they've accumulated all of your medical records, now they will have their own medical experts review the records to determine again whether or not they feel that they have valid defenses in this case. If they come to the conclusion that yes, they are totally justified in defending this case, then in all likelihood they will have no interest whatsoever in trying to settle and negotiate your case before trial, which means that in all likelihood at that point, your case will go to trial. Now, let me share something else with you that might not make sense. It might be counterintuitive. Even if your case goes to trial, did you know that there is still the possibility that you could settle your case in the middle of trial? It's true. Even during jury selection, at the very beginning of your trial, it is possible to try and settle your case. Even if your case goes all the way to the end of the trial, and now the jury is now being tasked with determining whether or not the doctor was careless and violated the standards of care, which caused you harm and injury. Once the jury is asked to go ahead and render a verdict, while they are deliberating, did you know that it's still possible to settle your case at that point before the jury comes back with a verdict? And here's something else you might not know. Did you know that before the jury comes back into the courtroom and reveals their verdict, it is still possible to settle your case? So there are many different opportunities, if they arise, to try and settle your case without the need to get to trial, or even if you are at trial, there are still opportunities, many times, in which to go ahead and try and negotiate. Does it mean you'll be successful? No, it doesn't. However, as you're trying to decide whether or not to go forward with a potential case, you're thinking, I don't want to spend the time and effort and energy going 2 or 3 years through the litigation process because I know before I even start, I never want to go to trial. In that instance, what's the chance that my case would settle? The bottom line is, we have no way of knowing at the very beginning. So why do I share this with you? I share this with you to help you understand how these types of cases work in New York. In all likelihood, you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.